Councilman Howell shows up, that'll be fine. If Chief Baker shows up, that'll be a help also. I'm Greg Seabury. This is a meeting. The purpose of it is to discuss a use of public ground ordinance. Members of the committee are myself, Councilman Fred Visconti, Councilman Mike House. In attendance also is Corporation Counsel Les Pinter, Assistant Corporation Counsel Dan Casagrande, Park and Rec Director Nick Planis, PJ Punty from the Mayor's Office, Antonio Alderola from the Public Works. Now, I'm going to read into the minutes the letter that we received last, is dated January 24th from the Mayor, which initiated this. Dear Council members, my office and the Office of Corporation Counsel have been working on updating the ordinance language regarding the use of public parks, streets, sidewalks, and other public grounds. Please appoint an ad hoc committee for the consideration of potential ordinance amendments. The draft will be available on the committee at the first meeting, which it is here tonight. Please contact my office if you have any concerns. Sincerely, Mark D. Bell. Now, with that, I'm going to ask Assistant Corporation Counsel Dan Casagrande to give us some sort of an update as far as what's going on.
Thank you, Mr. Chairman. I think the members of the committee have in front of them a draft of an ordinance that I have put together. And just for the record, it has been reviewed by the mayor with his approval. And I'm just going to give Mr. Ellis a copy of the ordinance. And also, I've talked to the chief about it, and Mr. Kaplanis, and they're generally on board with the concept. That obviously they may have some minor points or other points that I haven't yet addressed, but the main thing is I wanted to keep them in the loop as we go forward with this. And essentially this is a camping ordinance, or better stated, an anti-camping ordinance. The genesis of this is, as you may remember, last year there was an encampment out on City Hall Green last summer. And that issue led us to look at our ordinances and regulations, and we realized that we really did not have in place any kind of a comprehensive ordinance or scheme that would tell people when and where, and if at all, they're allowed to camp on city public property. And so the mayor and Attorney Pinter asked me to conduct some research on the issue. I have done substantial research. What you have before you is the product of really an amalgamation of a lot of the ordinances and regulations that I've reviewed nationwide, and what I believe is the best template for going forward. And basically, the first section would be added as Section 13A6 of the code. The first section is a statement of purpose, and very briefly, I'm not going to read it, but just to summarize, the statement of purpose indicates that it is intended to protect city interests which are jeopardized by the activity of camping on city property that is not compatible with or designed for such activity. It goes on to say that it's in the city's interest to be a good steward of public land, whether it's a park, a recreation area, or other open outdoor area, and manage it in a way to ensure that not only we here, but future generations are able to continue to enjoy those properties. Another important city interest addressed by the ordinance is that to make sure that publicly owned land is used properly, used for its intended purposes. And it says that the use of public land for a purpose for which it is not designed or made available to the public causes the property to deteriorate more rapidly, causes higher maintenance costs and security costs. Fourth, there are health concerns that arise out of camping activities, especially if you have a property where there's not adequate sanitary facilities. There's a risk of communicable disease, and that elevates what is not only an unauthorized use of the land into a potential public health concern. So that's another interest that we're trying to protect with this legislation. The common thread in property owned by the city is that it's owned, preserved, protected, and maintained using the public's tax dollars. And therefore, ensuring that that land remains available and accessible to everyone is an interest for which action is justified if not required. And therefore, the last section of the preamble says, at times, as in this instance, it becomes necessary to enact a proscription against unauthorized camping to ensure that these interests are protected. The second subsection is a definition of camping. There's no real prior authorship in this, but I basically took the language from definitions of camping contained in other statutes and ordinances around the country. And there's been a body of case law that's arisen involving camping, and I took a lot of the language from the cases that I've reviewed. Subsection C is I guess what you call the heart of the ordinance, that basically says that an area of city-owned land may be designated as a camping area either by the city council through ordinance or by the official department or authority responsible for the property. So if it's the Parks and Recreation Department, which is responsible for Parks and Rec, the director would have that authority to establish a certain park or a portion of a park as a camping area. If the city does designate areas as camping areas, the ordinance allows publication of that by signage on the property, advertising it, posting it to say that this area is available for that activity. And it also says that it directs the Park and Recreation Director to compile and post a list of all properties which are designated for camping on the city's website, so that people who want to know, they know where they can go. Right now, I will tell you the only area in the city that is designated for camping is Bear Mountain Reserve, and that's through a separate ordinance. So that already has been designated. The subsection D is the prohibition section. That basically says if a property has not been designated for camping by the city, it's unlawful for anybody to engage in the activity of camping on that property, knowing that the area is not designated as a camping area. It's not a strict liability type of ordinance. In other words, the person would have to have knowledge that he or she is not allowed to be there in order to be guilty of the violation. Subsection E basically allows the police, mostly the police, to, if somebody's found to be camping in violation of the chapter, that the police would be authorized to take steps to remove tents, toilets, other camping paraphernalia, and seize them, provided that whenever possible, that they would give appropriate notice to the people, saying, look, you need to move, it's not prohibited, we'll give you, and I didn't put a specific hour, a 24-hour notice thing. I think it's appropriate to leave that up to the discretion of the police as to what is reasonable notice. And there may be times when notice is simply not, it's not appropriate because there may be an imminent danger to public health and safety, and in which case the notice requirement is dispensed with under this subsection. Subsection F is the section that says who can enforce it, who's authorized to carry this out. Police officers are authorized to enforce all provisions of this section, including the removal of unauthorized persons and areas from areas not designated as camping. It also gives the Director of Public Works and the Parks and Recreation Director limited authority in the sense that they would be able to give the notice to people under subsection E to remove their items. But the police would be the logical people to say, well, okay, you now have to remove yourself and unauthorized items. G establishes the penalties. I put in a penalty of $100 a day. I know we've talked about this before on the council. You have the authority.
Dan's doing a lot of talking.
No, it's short.
Goes by the word.
That was only 15 minutes.
Time flies when you have fun.
I'm sorry, go ahead.
Yes, sir. I know we've talked about this in the council before. The statute authorizes you to have a fine up to $250. I thought $100 was a reasonable fine, or penalty, I should say. But obviously the council can change that up to a maximum of $250. Each day that the person remains in the property, knowing that he or she is not authorized to be there, is a separate violation. Danbury police officers are authorized to enforce the provisions of the section, in addition to any other available remedies they may have at law, by the citation procedure. So they could issue citations under 12-34 and 12-35 of the code. And subdivision 2 of the section also is basically a reminder to people that if you're on property knowing that you're not allowed or licensed to be there, and you get an order from a police officer or other appropriate official to leave the property and you don't do it, you're subject also to criminal prosecution under the trespass statutes. H is simply a section that says nothing in this section should be construed as preventing a department from enforcing other lawful regulations regarding city properties. That's really boilerplate. I is a severability section that basically says if somebody decides to take us to court for whatever reason, based on one or more of these sections, and the judge finds that one of the sections is illegal, to the extent possible, this says that that finding of illegality of one section will not doom the entire ordinance. The last one is the effective date, and the effective date is proposed to be October 1st of this year. Why are we proposing to do that? This is at the mayor's suggestion. What we don't want to do is be perceived as using this ordinance to target particular groups. We had the encampment last summer. There may be another encampment this summer on the city green. I don't know that yet, what's going to happen, but I do know that in some of the cases that I have reviewed, courts will look at the timing of the passage of these kinds of ordinances and look to see if it's really a ruse or like a concoction of the city legislature to actually target groups of people that they don't want using city property. Obviously, that's not the intent of this. That this ordinance applies no matter what your group is, what your message is entirely content neutral. But we thought that the more conservative approach was, let's let it be effective in the fall so that people will have a reasonable chance to become aware of its provisions, and we minimize, I guess is the right word, any potential argument along those lines, that this is really a ruse. That's the ordinance, and I'm happy to answer any questions.
Okay. Are there any questions, Fred or Mike? Fred?
Thank you, Mr. Chairman. Through the chair to Dan. Just for the record, natural green space, where is that?
Well, I mean, it could be open space areas. I mean, I don't have a catch-all definition of that for you. I mean, it's that phrase occurs throughout the ordinances and regulations that I've seen. So it's in, for example, I guess Terrywell Park in a lot of ways would be deemed natural green space. So it's intended to basically intended to say, look, if it's public property and it's a park or a recreation area or open space or other green space, including the green space out here on the corner of Deer Hill and West Street, unless it's expressly permitted, it's prohibited. That was the intent.
Go.
Thank you. To Attorney Casagrande. What, with all the wordage that we have in here, which is really good wordage, will it also allow someone to approach the city and ask for permission to use a certain area?
I believe so. If you look at subsection C,
That's relevant.
it allows the Parks and Rec director or the Public Works director to designate an area as camping. The concern I have though about, I think the intent of this is to have a designation that's not based on a request of a particular group. In other words, not have an ad hoc type of determination. That's where you run into trouble. If a Public Works director or Parks and Rec director has the authority to say, well, I'm going to allow this group to camp here tonight, but I'm not going to allow this group, another group, to camp there. Especially if the reason why that group wants to camp there, or one group, is to engage in expressive activity protected by the First Amendment. That's where you start running into trouble, because the courts say if a government official has unfettered discretion to deny one group a permit, but give another group a permit, that is potentially vulnerable to a First Amendment challenge. So, and maybe we can word this better, Fred, but the intent was it would be a designation on, not because, the Boy Scouts come to Antonio one night and say, well, we'd like to use this on Saturday night. I didn't envision that kind of ad hoc determination. I viewed it as more of a kind of a preemptive institutional determination. That doesn't make a lot of sense, but a determination made by the Parks and Rec director that certain areas of the city are appropriate, and then you could put signage up so that people know this is an area designated for camping. I don't know if that helps you, Fred.
You do? Go ahead, you're on a roll.
I lost my train of thought. So what you're saying then, XYZ comes in and wants to ask permission for a certain area for camping purposes. The department head, would that department head be the only one who has a say, or may it, or could it not come back to the council? Or?
It would be, well, it could be either through the council, so someone could come in and request an ordinance saying, please designate this area as camping. Or someone could go to Mr. Kaplanis and say, I'd like to designate this area as camping. The ordinance does say that if you're going to go to a particular department head and you want to designate an area, it has to be with the concurrence of the chief of police, so that security concerns are taken into account. I guess what I would say is, if someone came to Mr. Kaplanis and said, we would like, this portion of this park to be designated as a camping area, I think, at least how I would advise Mr. Kaplanis is that, okay, they've asked you to make this designation, but you have to look at it as a designation that's going to apply to everybody. So in other words, if you're going to say, I'm going to designate this area as a camping area, you have to be comfortable that that's going to be a camping area that's available to everybody, not just the one group that's asking for it.
All right, so Mr. Kaplanis wants to designate half of Rogers Park as a, is that a good one? Half of Rogers Park for a camping ground, or allow camping in that
In
area.
your backyard, right?
Yes, it is.
Big three.
I'm only using that as an example. That's your name.
He could do
He
it.
has the sole permission, would it?
If
would we
the
not
chief
have
of
any say in
police-
that?
The way this is written, if the chief of police concurred with Mr. Kaplanis' determination to designate half of Rogers Park, if they deemed it advisable to do so, they have the authority to do it.
With no
Now-
questions asked.
No questions asked.
I have a problem with that.
All right, are you done?
Yeah.
Then I want to throw something out. I think,
Okay.
this is my own personal opinion, Chief, Nick. I think if we open up any place, we're opening up a can of worms. We got a liability issue. Les, would that be correct? I mean, let's say that they, right in Freddie's backyard, Rogers Park, Nick gives somebody a permit to camp out there, and camping out, in these people's mind, is to have a campfire.
We would hold Freddie responsible.
All right, that's settled. I'm happy with it.
Does that solve that problem?
Yeah, that's good.
Restrictive,
You'd
right
be out
now,
there
they
with
wouldn't
short
do it.
Can you understand what I'm thinking if we offer anything, we're gonna have problems. Currently, we have Bear Mountain, you said, Dan,
Yes,
on a limited basis.
on a limited basis.
My own opinion is that I would not want to open up any grounds for camping, because I just think it's gonna be open. I think you're gonna run into problems with perhaps drinking, chief, with other activities that are illegal there.
So Greg, you're more against any designations. Freddie is
No, no, no.
uncomfortable with an individual.
No,
doing
no, I was just
designation.
using that, I'm sorry to interrupt, I was just using that as an example. I totally agree with what we're.
No, it sounded like you were more comfortable with the council also had a say in which ones.
Yeah, I would like,
Okay.
if
Yeah, you
possible.
could do that. I mean, this is just a draft. I mean, you could simply say that an area may be designated by the common council by resolution of the city council.
Yeah, definitely.
And, you know, the council could obviously seek the input of the chief and Mr. Kaplanis. But yeah, as written, and again, this is modeled after other ordinances, but you raise a good point. The council would not have input into a decision by these two gentlemen on particular areas. So we,
I'm sorry,
no, go ahead.
can I?
Oh, sure, Fred, take over.
Is that the way it has to be written? That-
No, no, I'm saying you could
Could there be
change.
different languages?
Yeah, you could simply say the area could be designated for camping by resolution of the city council.
Or we can also say there is no camping.
There's no camp.
Or yeah, and you have to deal with the Bear Mountain ordinance that prohibits
That's your
camping on
job.
a limited basis, but,
That's you guys' job.
well, right, we'd have to do that.
Could I just,
Sure, go ahead.
I'd just like to get some feedback from either, well, the chief and Mr. Kaplanis.
Well, I have no plans of making any area as a designated camping area. I mean, in the years that I've been on the job, there has been some requests through the Conservation Commission for Bear Mountain. They're the shepherds of that property. And that's, you know, been few and far between. Any other request that has ever come through the office, and if there has been, it escapes me right now, but anyone that calls up and asks, I have people that, you know, call up and say, well, we have an RV, where can we park it, we're coming through town, we wanna, you know, park our RV and stay over, and I say, we have no such area, so I have no intentions of seeking a spot for any of that to occur.
How about your driveway for that RV?
Sure, you can get it up there.
Chief, you wanna?
Well, I just, correct me if I'm wrong, but I don't think this is gonna be done on an ad hoc basis. This is more establishing permanent areas for camping.
That's the intent.
That's the intent. And, you know, by not acting on it, could be some unintended consequences too, because if somebody does start camping, we're not gonna have any tools to deal with it. Where, you know, it's gonna have a policy, clearly from, you know, this day forward, you know, we'll have tools that we can use to react to camping that might occur. So I think it's important to do something, you know. And maybe it's what Fred is suggesting, that by permission of the council or something.
I mean, doesn't it in so many words say that here? I mean,
Well, it says
Or.
through ordinance or by the official in charge of the thing, so,
Well, the city council is mentioned here through ordinance. I mean.
yes, or by the official, so it's an either or, the way it's drafted. But, Fred, you raise a good point, I mean, you could certainly direct me to change it to say, look, the only way we're gonna designate camping is through an ordinance of the council.
I would like to see it.
Thank you.
Through the chair to Attorney Cascarino, couldn't we also define camping in our own words to limit what really they can do? So maybe, you know, deterring people that way without discriminating totally, you know, against, you know, about shutting down camping. But you, obviously, I doubt if they allow campfires at Bear Mountain, right? I doubt that. You know, obviously, you know, you don't want alcohol, you don't want fires, you don't want, you know, loud noise and stuff like that. And, you know, that may be another way, if
mean, the legal answer is your power to prohibit all camping also implies the power not just totally prohibit it, you could permit it under certain
Right.
circumstances.
Can't we just redefine what camping is in Danbury?
You could.
You know, if
That's not, I mean, I will tell you, that's not how most cities have chosen to go. I mean, a lot of the bigger cities, they, you know, and frankly, most of the cases that, where this has come up, you have big cities where they have multiple areas designated for camping, including state parks, et cetera. We're a relatively small city. But most of those cities that have adopted these kinds of ordinances say basically this: unless we allow it, as defined in the language section, it's prohibited. But certainly you could, I mean, I guess the danger is, you know, how do you define it in such a way that provides a reasonable person with notice of what is and isn't allowed? You know, that would be the issue raised by the way you want to go. But it's certainly legal.
I don't think other than Boy Scout troops that they're really gonna target Danbury to go camping anyway, so.
I mean, there's no real history of people requesting camping in the past several years here, is there?
That was sort of a question I was waiting to offer to either Antonio, PJ even, Chief and Nick. Do we know of any existing camping other than Bear Mountain? I don't think I've ever seen anything in Danbury, so I'm wondering if there's someplace that they're doing that I don't know.
There is a place for RVs up at the center, Connecticut Center.
Yeah.
Is there
Is it a rest stop?
Is there
They
some?
do allow RVs.
I didn't even know.
That's RVs, it's not camping.
Yeah.
Okay. Anything else from the committee? All right, Les, where does this go from here? I'm going to ask you to throw some direction.
Well, the committee can, after hearing Dan's presentation and the proposal, can recommend something to the full council, either in the way of furthering the review and adoption of the ordinance and public hearing and all that
Right.
will be done. Or recommending you can table it, consider it further if you want to think about it. I mean, those are you can recommend changes, Dan, you can bring back and have another meeting, another possibility based on some comments. So those are the three options, I guess.
Then I'm going to open up to Mike and Freddie. What are your thoughts about what Les just said?
I think if we could continue it till the language has changed, what we talked about this evening, and then come back and we could probably wrap things up.
You good with that, Mike?
Yes, that's.
Okay. Then how about, do I do that, or is a motion has been made?
Just make a motion of some kind.
Uh,
You want to table it?
Yeah, I'll make a motion to table until further language can be changed, brought back to the committee.
Okay, Mike, can you second that?
And Mr. Chairman, just so I'm clear on the intent, the proposed change would be to basically say that the council would be the sole
That's-
authority to determine whether to designate an area.
Exactly. Is that?
That's-
fine, yeah.
That's Freddie, that's what your
Yeah, that's fine.
recommendation is.
Okay.
That's all right.
Greg?
Okay, motion's been made. Second. All those in favor?
Aye.
Okay, the ayes have it, and we will come back. Let's see no further business. Can we have a motion for adjournment? And second, Mike.
I'm not sure that.
Okay, all those in favor of
Question, probably
adjournment,
a
please say
state-
aye. Aye. Thank you, ladies and gentlemen.
Good morning. Chief Harold, Danbury Fire Department here. I'd like to talk to you a little bit today about disposal of ashes, either from your fireplace, your fire pit, or your charcoal grill. Unfortunately, many times during the year, improper disposal of these ashes has resulted in fires, both in Danbury and other areas. So we would like to remind you of a few key points. Never ever put ashes in any kind of a combustible, or in the case of plastic, a meltable container. Although the ashes may feel cool, ashes often harbor a few hot spots, and these can indeed burst into flame when unwatched or put away in a place unsafe. For example, on several occasions in the city of Danbury, we've had ashes put into cardboard boxes, paper containers, or plastic barrels. These have been placed outside, seemingly safe. However, the heat builds up, fire reignites, and often on a wooden deck or against the siding of a home can result in a fire. So please, use a proper disposal container. This means metal implements to move the ashes, a metal implement to carry them, such as a bucket or a covered container, and remove them entirely from the home or the garage. Put them outside, not against the building, far away from anything else that's combustible. By doing this, you will ensure yourself, your family's safety, and the safety of the neighborhood. Thank you very much for listening.